defendant made a decision to use harassment of the victim repeatedly. And so here we are again. This time the case is not just going to disappear. So
you did commit the offense of stalking on an Erica Jemerson Bird. Finished as a aggravated stalk. Yeah, if you don't show up, I know my way around Alabama. I'll come find you.
Good morning, John. That's the Republican Freedom on behalf of people.
Your name?
John Bird.
Mr. Bird, you are before the court on 2 felony complaints. Case ending in 0228. That alleges that on or about August 9, 2024, at location of 8790 MacArthur Boulevard, Superior Township, that you did commit the offense of stalking on an Erica Jemerson Bird. You understand? Finished as a aggravated stalking. You understand the nature of that charge, sir?
Yes.
That's a felony punishable by up to 5 years incarceration and $10,000 fine plus court costs. Probation could be ordered for any term of years not less than 5. You understand that, sir?
Yes.
Count 2 on that complaint alleges the offense of malicious telecommunications service involving a domestic relationship. You understand that charge, sir?
Yes.
Misdemeanor punishable by up to 6 months incarceration and $1,000 fine plus court costs. Understand that?
Yes.
On the other case, the case ending in 0229, that alleges that on or about August 10, 2024, at the location, same location of 8790 MacArthur Boulevard in Superior Township, that you did that time also commit the offense of stalking or aggravated stalking. You understand that charge?
Yes.
Felony, 5 years, $10,000 fine plus court cost. Probation for not less than 5 years. You understand that, sir?
Yes.
The other is also the same charge of malicious use of a telecommunications device involving a domestic relationship. Misdemeanor punishable by up to 6 months, $1,000 fine plus court costs. You understand all of that, sir?
Yes.
First question I have for you is, do you want to be represented by an attorney?
Yes.
This is a public defender case.
Yes, Your Honor. Assistant Public Defender Nicholas Bukovich on behalf of Mr. Bird.
You waive for further formal reading.
Yes, we will waive further formal reading, be standing mute as to the charges.
And then having waived formal reading, standing mute as to the charges. I'll set a probable cause conference in this matter for
April 30th.
MP. April 23rd, 2026, 9 a.m. As to bond.
Your Honor, case is reported to proceed at the bond information form from office.
I believe I am. Yes, I am.
For the record, Your Honor, we're requesting a $50,000 surety bond, as well as a GPS tether with a hot zone of 8790 MacArthur Boulevard in Stalking. We are with a criminal contact with the victim at 85, as well as the conditions, including those that firearms and or other weapons based on the state of domestic offense. Your Honor, in this case, the defendant was texting the victim friendly messages using his mom's phone to tell the victim. Some of the threatening messages included, like, even if see, talking, you bitch, gotta learn to my name and issue out. Don't be home. Victim, this is a reauthorization, Your Honor. So initially the cases were dismissed. However, defendant made the decision to continue his harassment of the victim repeatedly. And so here we are again. This time the case is not just going to disappear. So with all tight honor, that is our.
Your Honor, at this time, I would be requesting a personal accountant's bond on my client's behalf, as indicated by APA Town Hall. This is a reauthorization. These cases were already litigated. He is here purposely availing himself to the court today to handle these matters. He is not running away from these matters, as indicated, he is here standing next to me right now. He does have full-time gainful employment. I do not believe there will be issues of any no contact or no go to orders. At this time, Your Honor, based upon the fact that my client is here trying to get these matters handled on reauthorized cases, I believe a personal conscience bond would be appropriate.
Well, as to the conditions of the defendant's release, I would indicate, first of all, that there is to be no use and or possession of any alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes.
You are not to leave the state of Michigan without permission of the court. I will also indicate that you are not to purchase, possess a firearm, ammunition, dangerous weapon, or anything fashioned to be a weapon. You understand that?
Yes.
You are ordered not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You understand that, sir?
Yes.
I will also indicate that you are not to have contact by any means whatsoever with Erica Jimerson Bird. You understand that?
Yes.
And when I say no contact, I mean absolutely no contact except with a civil standby. You shall not attempt to have any direct or indirect contact with that person, either through others or through yourself. You're not to do that with any electronic communication that's including but not limited to phone, email, texting, internet, and you are not to mention that person on social media or on the internet. You understand that, sir?
Yes.
I'm also going to indicate that you are not to go to the 8790 MacArthur Boulevard. You understand that?
Yes.
Except with a civil standby. You understand that, sir?
Yes.
You are not to violate any criminal law. You are to personally appear at all court proceedings. You understand that these conditions that I've given would apply whether you're in custody or you are released. You understand that, sir?
Yes, sir.
I am going to, a review of the bond sheet, everything. I am going to set the defendant's bond at about $50,000 cash surety on each case. Defendant is ordered remanded. If defendant is released, he's to be placed upon a home confinement GPS tether. Thank you.
This bond ruling shows that Judge Simpson is focused on managing the risk, not just on the fact that Mr. Bird came to court voluntarily. The defense made a reasonable argument. These cases were refiled. Mr. Bird came to court on his own. He has a full-time job, and his lawyer says he is trying to deal with the charges instead of avoiding them. But the prosecution focused on something more serious. They alleged that the behavior continued even after the earlier cases were dismissed. Because this involved an aggravated stalking case, Judge Simpson wanted strong restrictions to prevent any further alleged contact while the case is pending. That is why the judge went beyond simply telling him to stay away. Mr. Bird was prohibited from contacting the person directly or indirectly, including through other people, electronic messages, or social media. He was also not allowed to go to the MacArthur Boulevard address unless it was part of a civil standby. These conditions were designed to prevent any possible loopholes. The judge also set a $50,000 cash or surety bond on each case, along with GPS home confinement if he is released. Do you think the defense's voluntary appearance argument deserved more consideration, or did the allegations justify these strict conditions?
On behalf of Mr. Tucson.
Good morning.
Morning. You're
Reginald Matthew Tucson.
Thank you. What are we doing on this?
Yeah, we would like to adjourn this matter, but we also would like to define when appropriate.
Public cause conference will be adjourned April 30th, 2026, 9 a.m. Esteban.
Yes, Your Honor. Mr. Tucson we're asking for a bond modification to his PR bond. If the court could release his $100 back to him, because he's currently homeless, standing in a shelter right now, does not live here. He lives in Alabama. Right now, we don't consider him a threat to society. These charges are 4 years old, and he showed up today. He's not on the tether, so that shows that he will continue to show up for court. Oh, and he he came from Alabama to turn himself in as well.
You did?
Yes, Your Honor. And what it was, when I think I was in front of you, you wanted to give me a PR, but I said
I wouldn't.
$100 bond because I don't want to miss my court date. So I ended up reprimanded to the county over the weekend.
That doesn't sound like something I do.
Or maybe it was the other.
I probably was somebody else.
I knew I had to see you.
I don't think he'd have to go downtown Ann Arbor to get the money back. Know that if that happens, and he doesn't get 100.
10%. I know.
Yeah, we take a 10%.
I understand, sir.
The biblical thing. What?
No, it took 10%. I didn't know that.
Fees cost.
We don't really take it. That's kind of harsh.
Right. It's a thing.
Taking
Process.
service fee.
Yes.
That's what I've been able to come up with, isn't it? Yes. All right. Well, what? Otherwise, he doesn't have any money.
Exactly.
No.
Exactly. And this would really help him out.
I usually don't.
This second bond hearing is very different from the first one. Mr. Toussaint's lawyer was not mainly arguing that the charges were weak. Instead, the attorney gave the judge several reasons why the bond should be reduced. The charges are 4 years old. Mr. Toussaint traveled all the way from Alabama to appear in court. He is currently homeless and staying in a shelter, and getting back the $100 he already posted would help him financially. That makes the defense argument more specific because it focuses on both his history of appearing in court and his financial situation. There was also an interesting moment when Mr. Toussaint said he remembered Judge Simpson previously wanting to give him a personal recognizance bond. Judge Simpson immediately said that did not sound like something he would have done. Instead of arguing with the judge, Mr. Toussaint admitted that he may have been thinking of someone else. That helped keep the hearing focused on his request. Judge Simpson also pointed out that he normally does not return money that has already been posted, meaning the defense was asking for an exception. Would you have granted the request? More importantly, does traveling from Alabama to appear in court show enough reliability to justify reducing the financial burden?
All right. I'll set his bond at a $5,000 personal cognizance in order that the bond that was posted be returned to the defendant. Now, if you don't show up, I know my way around Alabama. I'll come and find you. Hear me?
I hear you, Your Honor.
Oh,
Yeah, but
See.
no.
All right, sir.
yes.
Before you leave, you'll need to see my staff. Okay, because otherwise, just about how to get your money back.
Okay.
Okay.
No problem.
All right. Thank you.
These two hearings show why bond decisions can be very different, even when both defendants voluntarily come to court. In Mr. Bird's cases, Judge Simpson set $50,000 cash or surety bonds on each case. If released, he would also have to follow GPS home confinement and strict no-contact and location restrictions. The defense focused on his job, his voluntary appearance, and the fact that the cases had been refiled. But the prosecution focused on allegations that the harassment continued after the earlier cases were dismissed. The judge's conditions were designed to address those specific concerns without deciding whether Mr. Bird is guilty. Mr. Toussaint received a very different result. His lawyer pointed out that the charges were 4 years old, that he traveled from Alabama to appear in court, and that he was homeless and needed the money he had already posted. Judge Simpson eventually reduced his bond to a $5,000 personal recognizance bond and ordered the previously posted money to be returned. Even the judge's joking comment about knowing his way around Alabama carried an important message. This new bond depends on Mr. Toussaint continuing to appear in court. The bigger lesson is that bond is not simply a price placed on a criminal charge. Judges look at each person's situation, including the risk of not appearing, the allegations, possible safety concerns, and the defendant's past behavior. Which ruling do you think was a harder decision for Judge Simpson? If you found this case interesting, hit like, share your thoughts in the comments, and subscribe for more courtroom breakdowns.